So the Hong Kong court does have the discretion to wind up foreign companies in particular circumstances. The first and most important rule that the court applies is that a company should ordinarily be wound up in its place of incorporation. But provided particular criteria are satisfied, there will be some cases where the court will wind up a foreign company in Hong Kong. The first lot of criteria that need to be satisfied come from the company's legislation. You would need to show that either the company has dissolved or ceased to carry on business, that it's unable to pay its debts, or for other reasons it's just inequitable to wind the company up. The most common criteria that most creditors will satisfy is that the company is unable to pay its debts. You would normally invoke this procedure by an ordinary statutory demand, which you would do for a domestic company. So that means you serve a notice of payment on the company. If it's not repaid within 21 days, the company is deemed to be unable to pay its debts, in broad terms. That's the most common way that you would proceed. The second lot of criteria which you need to satisfy comes from the common law. And the courts have held that there are three what are called core requirements which dictate how the court will exercise its discretion and whether or not it will wind up a foreign company. The first of those criteria is that you need to show that there is a sufficient connection to Hong Kong. This is ordinarily shown by assets within Hong Kong, but it's not the only means to satisfy that criteria. The second is that there's a reasonable possibility that the winding up order will benefit those applying for it. And the third is that there must be persons within the jurisdiction with a sufficient connection to the company within the jurisdiction who will get a sufficient economic outcome from the winding up. And ordinarily, this is shown by creditors being present within the jurisdiction with material debts, either one creditor or multiple creditors. Again, these are just discretionary requirements which the court will consider, but they're very important to establishing the ability to wind up a foreign company. Finally, there is another option which the court has that doesn't go so far as to wind up the current foreign company, which are what are called recognition orders. And I mentioned that generally the Hong Kong court will require that a company, they will want to see that the company has been wound up in its place of incorporation. If that has happened and a liquidator has been appointed in the foreign company, in the foreign country, then it can apply to the Hong Kong court for recognition of their appointment in Hong Kong. And the advantage of this approach, provided that the insolvency regimes between the foreign country and Hong Kong are broadly similar and meet particular criteria, then it means that the foreign liquidation can be recognised in Hong Kong and that the Hong Kong court has power to grant particular powers to the liquidator to take steps that an ordinary domestic liquidator could take, such as to obtain the books and records of the company or to conduct certain investigations and examinations.